All right, I kind of briefly discussed this, but reciprocal discovery or mutual discovery is barred in criminal misdemeanor cases. That cannot be more clear. There was a rule that went up, a proposed rule to the Michigan Supreme Court, and it was the one thing that was rejected out of this new district court rule. They said, no, we're not going to have any reciprocal discovery. But under Brady versus Maryland, gosh, I remember learning about that case in law school. That's the case that says that you're required to give me exculpatory information. So what's exculpatory? Well, we know that this is a nebulous little thing as to what's exculpatory, but you are going to allege that it is exculpatory. And I can provide an explanation for any one of the things that I'm asking for. Now, is it a fishing expedition or is it legitimate? Truth is I don't know until I start to get some of this information because I'm doing this in every single case. But if I weren't doing this in every case, I wouldn't be getting a lot of this information that, oops, it does turn out to be exculpatory, because the prosecutors aren't going to do that work for you. The discovery and confrontation, this is an interesting line, because we've heard from Justice Scalia so much about confrontation with the Crawford decision all the way on up to Melendez-Diaz. What is confrontation? One of the cases that's floating out there says that confrontation allows you access to discovery. Why? Because in a DUI case or other cases, you might have an expert witness. What does that expert witness need to look into the case in order to be able to meaningfully cross the state's expert witness? They need access to, oh, I don't know, the data master itself, the gas chromatograph up in Lansing. They need access to the laboratory. Can you ask for these things? You certainly may. Can you file motions for them? You're certainly allowed to. And if you're not allowed access to these things, what is the remedy? Why are they suppressing this? Why aren't they allowing your expert to access it? Why aren't you giving meaningful confrontation against the government's witnesses? All right. I used to put a subpoena in with my little packet of information in every single case. And Tom Loeb and a few other people kept saying, you know what, you're not ethically allowed to do that. It's kind of really pushing it's pushing it a little too far because you can't subpoena things in criminal cases, just like you can't ask for a deposition. There's a little question about this with the prosecutor's use of investigative subpoenas. But hey, let's forget about using a subpoena to obtain documents. Instead, why don't we subpoena the chief of police or the local shift commander of the Michigan State Post that you're dealing with? Well, what are you subpoenaing them for? I would like you to come to court. Sure. Why? Well, because you've got some documents that I want you to bring. How many times is the chief of police for some local jurisdiction going to show up for your pretrial without expressing some sort of anger or frustration with the prosecutor that you keep making him come to court when he's a busy man? You can always ask for a witness to come to court, and you can ask that witness to come to court with documents. Oh, I wanted to go through these ABA rules here. One of the things that I get a lot of flack from judges is some of these 3.1, what's a frivolous motion? There was even a question that came up over in Illinois with a different DUI lawyer. They said that filing a generic motion challenging the stop and the arrest of a person was frivolous because he files the same motion in every single case. Well, in every single case, the police don't have a warrant for the person's arrest. There's some reason for the stop, I assume, but it's the burden of the prosecution to establish that. So is that motion frivolous? The ABA notes under the 3.1, this was not adopted in Michigan, but it says that this is in the notes. The lawyer's obligation under this rule are subordinate to federal or state constitutional law that entitles a defendant in a criminal matter to the assistance of counsel in presenting a claim or contention that would otherwise be prohibited. There's a little tension there between what's a frivolous motion and what's fair game when you're defending somebody who's potentially going to be incarcerated as a result of this criminal conviction. So when the prosecutors start whipping out names like, or court rules like 2.114 and allegations that things are frivolous, you counter them by saying, hey, I have an ethical obligation to pursue all legitimate avenues to try and vindicate my client.